Something happened early this morning that people are still trying to wrap their heads around. At about 6:47 a.m., federal marshals intercepted Donald Trump at Dulles International Airport as he was preparing to board a private aircraft headed for Dubai. And the next 11 minutes, well, they were unlike anything we've seen in modern American legal history. A former president physically stopped from leaving the country under an emergency judicial order while criminal proceedings are actively unfolding. Just pause on that for a moment, because what unfolded in that terminal wasn't just some routine enforcement action or a technical legal step. It was a stress test, maybe the most serious one the American justice system has faced since Watergate. A moment where institutions had to decide whether the rules actually apply when someone who once held immense power appears to believe they don't. Now, before we go further, if you're someone who follows how these things develop, you might want to stay close to this channel. The next 72 hours could shape the direction of this entire story. Here's what we know so far. According to 3 independent sources, 2 connected to the Federal Marshal Service and 1 inside the Justice Department, the emergency order came from Judge Catherine Valdez of the United States District Court for the District of Columbia at 5:23 a.m. The filing was sealed, but for a very short window, it appeared in the federal court system's PACER database. 14 minutes, then it disappeared. During that brief appearance, observers noted the document included 23 pages of supporting material, flight manifests, financial transaction records, communications intercepts, all suggesting prosecutors believed there was an immediate risk Trump might attempt to leave the country. And the flight itself? That part is verifiable. Public flight tracking systems show that a Gulfstream G650 connected to a Delaware company tied to Trump Organization networks filed a plan at 4:47 a.m. The scheduled departure time was 7:15. Destination, Dubai International Airport. Sources connected to airport security at Dulles say Trump arrived at the private aviation terminal at 6:41 a.m. He wasn't alone. 2 private security personnel were with him, along with his attorney, Alina Habba. But federal marshals were already inside the terminal. They had received the court order 78 minutes earlier. The confrontation lasted 11 minutes. Witnesses say voices were raised. Trump appeared visibly agitated. Habba repeatedly demanded to speak with supervisors. Then, at 6:58 a.m., something very specific happened. Trump's passport was physically taken from him. 4 minutes later, at 7:02 a.m., the aircraft departed without him. He was escorted to a secure waiting area and remained under marshal supervision for 47 minutes before being released. The conditions were explicit. He is not permitted to attempt to leave the continental United States. Now, here's why legal experts across the political spectrum are calling this extraordinary. Professor Michael Harrison at Georgetown Law, someone who has testified before Congress on limits of executive power, explained within hours that stopping a former president from international travel under an emergency order, while the charges themselves remain sealed, represents a dramatic assertion of judicial authority. Former federal prosecutor Sarah Chen, who spent 16 years handling corruption cases in New York, said the threshold of evidence required to convince a judge to take that step must have been overwhelming. Judges do not invite that level of political scrutiny without documentation they consider airtight. And the timeline leading up to this moment matters a lot, because this didn't appear out of nowhere. It was the result of decisions building over roughly 14 months. Back on January 8, 2024, the special counsel's office submitted a sealed motion to Judge Valdez requesting enhanced monitoring of Trump's movements. Intelligence intercepts had reportedly suggested early discussions about extended travel to countries without extradition treaties. The filing remained sealed, but multiple sources say it referenced conversations between Trump associates and representatives connected to the United Arab Emirates, Saudi Arabia, and Russia. Then, on February 22nd, Trump's legal team requested permission for a 10-day trip to Scotland to visit golf properties. The judge approved the trip, with conditions. 72 hours notice before travel. Passport surrendered upon return. Trump complied. He traveled from March 3rd through March 11th and returned the passport as ordered. Prosecutors later pointed to that compliance as evidence that Trump clearly understood the court had authority over his international travel. But things shifted in April. On April 14th, new intelligence intercepts were reportedly presented to Judge Valdez, indicating Trump had spoken with Emirati officials about potentially staying long-term at a luxury property in Dubai. According to sources familiar with the briefing, the conversation referenced timing that overlapped with an expected superseding indictment later that month. And on April 29th, that indictment was filed under seal, 34 additional counts, obstruction of justice, witness tampering. Trump's attorneys were notified, but the document itself remained sealed while arrangements were being discussed for a surrender process. Sources say that moment may have been the turning point, because shortly after that, investigators began noticing something else: financial transfers. Between May 3rd and May 12th, roughly $47 million moved through a network of shell companies into accounts in Dubai and the Cayman Islands. The transfers were structured carefully to avoid automatic reporting triggers, but together they represented the largest movement of Trump-linked assets outside U.S. jurisdiction since he left office. Forensic accountants working with prosecutors flagged the pattern on May 18th, and from that point forward, investigators reportedly began treating the situation very differently. Now, there's another figure in this story you should understand: Judge Catherine Valdez. She's 62 years old, appointed to the federal bench by President George W. Bush in 2006. Over more than 200 criminal cases, not a single one has been reversed on procedural grounds. Before becoming a judge, she spent 11 years as a federal prosecutor handling organized crime and racketeering. In other words, she's seen every tactic defendants use to avoid accountability. And according to people familiar with the events inside her chambers, when prosecutors presented the evidence package to her on the evening of June 1st, her conclusion was immediate. They believed this defendant was preparing to flee. What happened next, the phone call, the post in the middle of the night, and the flight plan filed just hours before the airport confrontation, is where this story begins to move even faster. And that's the part most people still haven't heard. So let's pick up right where we left off, because the sequence that followed is what appears to have pushed this situation from concern into immediate action. On the evening of June the 1st at 8:47 p.m., Trump reportedly had a 43-minute phone call with his pilot and the head of aviation operations connected to his aircraft. According to sources familiar with the intelligence intercepts, that call was captured under existing surveillance authorities, and what investigators say they heard during that call is what changed everything. Trump allegedly instructed his aviation team to prepare the aircraft so it could depart the country on very short notice, not days, not even a full day. He wanted the ability to leave within 4 hours. No advanced filing, no warning. Sources say he even referenced how he handled legal pressure during his business career years earlier, describing situations where he would simply leave the country abruptly when creditors or regulators began closing in. Investigators interpreted that call as the moment the situation crossed a line, not theoretical anymore, concrete. Then, just a few hours later, something else happened. At 2:34 a.m. on June 2nd, Trump posted a message on Truth Social. The message talked about foreign business opportunities and international partnerships that he claimed fake news media and corrupt prosecutors wanted to prevent. But here's the detail that caught investigators' attention. The post was deleted 11 minutes later. Screenshots had already been captured by multiple monitoring services, and prosecutors later pointed to the message as evidence that Trump might have been shaping a public explanation for leaving the country. Then the timeline accelerated. At 4:47 a.m., the flight plan for the Gulfstream jet was officially filed. At 5:23 a.m., Judge Valdez issued the emergency judicial order. And by 6:47 a.m., federal marshals were standing inside the private terminal at Dulles waiting for Trump to arrive. If you've been following closely, you might notice something here that doesn't look accidental. According to sources familiar with the Marshal Service's operational planning, they already knew the aircraft was scheduled to depart. They knew Trump was expected at the private terminal, and they knew roughly when he would arrive. This wasn't a random airport encounter. It wasn't a routine security check that happened to catch someone trying to leave. Agents were positioned ahead of time. That level of preparation suggests investigators were receiving real-time intelligence about Trump's movements and intentions. And when law enforcement prepares that way, it usually means the situation is being treated as something far more serious than routine pretrial monitoring. Some officials have privately compared it to how authorities track international fugitives or espionage suspects, people they believe might disappear across borders if they're not stopped quickly. Now, there's another piece of this story that hasn't been widely discussed. Sources connected to officials in the United Arab Emirates say preliminary conversations had taken place about extended accommodations at a Trump-branded property in Dubai. These discussions, according to those sources, reportedly touched on logistics, security arrangements, communications infrastructure, even potential legal protections that might complicate extradition requests from the United States. The Emirati government, they say, had not made a final decision about whether any such arrangement would actually be approved. But the fact that those conversations reached that level of detail suggests Trump's team may have been exploring the possibility seriously, not just talking about it hypothetically. And here's something else that changes the picture. This morning's passport seizure wasn't the first time federal authorities had restricted Trump's ability to travel internationally. Court filings, still sealed but described by people who have seen them, indicate his passport had been under what's called judicial supervision since February. That means any international travel required formal requests and advance notice to the court. In other words, travel restrictions were already in place. The emergency order this morning didn't create those restrictions. It escalated them. Prosecutors reportedly argued that attempting to leave the country without notifying the court violated the spirit of those existing conditions, and that the only way to ensure compliance was to physically prevent departure. Now, there's another development that makes this situation even more complicated. Several constitutional scholars, including both liberal and conservative voices, say the events this morning may establish a legal precedent that has never existed before. Professor David Armitage at Harvard Law School told reporters that preventing a former president from international travel represents an assertion of judicial authority that earlier generations of judges might have considered politically impossible. His argument was simple. If Judge Valdez took that step, the evidence she saw must have convinced her that political hesitation could no longer outweigh basic law enforcement concerns. Former appellate judge Patricia Hammond, who served on the Ninth Circuit, explained something similar during an interview this afternoon. She said, the emergency nature of the order strongly suggests Judge Valdez concluded Trump posed an imminent flight risk, not a vague concern. A real possibility that he could leave within hours if nothing stopped him. And if that assessment is correct, it means the judge effectively determined that Trump was actively attempting to flee federal jurisdiction at the exact moment she issued the order. Now here's where the story turns again. Because according to sources familiar with the sealed superseding indictment filed back on April 29th, the new charges may involve more than additional obstruction counts. They reportedly include conspiracy allegations that implicate multiple individuals inside Trump's inner circle. 6 co-conspirators are said to be named in the document, 3 of them described as executives connected to the Trump organization with direct family ties, And according to investigators who have been briefed on the matter, the possibility that members of his own family could face federal prosecution may have changed the entire calculus. Some believe that prospect may have been the moment Trump began considering permanent departure from U.S. jurisdiction. Because once those charges become public, the legal exposure expands dramatically. And that's the part of this story everyone is now watching closely. Because the next decisions from the court, from prosecutors, and from Trump's legal team could reshape everything that happens from here. So where does all of this leave us right now? That's the question everyone inside the legal world seems to be asking today. Because once the events at that airport terminal became clear, attention immediately shifted to what happens next. There are several developments people are watching closely over the next few hours and days, and each one could change the trajectory of this situation. The first involves Judge Catherine Valdez. Legal analysts expect there is a strong possibility she will release at least a partially redacted version of the emergency order that authorized the marshals to stop Trump from leaving the country. Courts often do this when a sealed action creates significant public interest, especially when media organizations begin arguing that the public has a First Amendment right to understand the reasoning behind extraordinary judicial actions. If that happens, the document could reveal what specific evidence convinced the judge that Trump represented an imminent flight risk, not speculation, actual findings. And that would be the first official confirmation of the intelligence and financial information that investigators are currently describing only through anonymous sources. The second development people are waiting for involves Trump's legal team. They now face a decision that could come very quickly. They can challenge the passport seizure and the travel restrictions through an emergency appeal, or they can accept the conditions the court has imposed. But filing an appeal carries its own complication. To succeed, his lawyers would need to argue that Trump was not attempting to flee the country. And given the timing of the flight plan, the destination, and the financial transfers investigators have already identified, that argument may not be easy to make. So the legal strategy they choose will tell observers a lot about how confident they feel about the facts surrounding this morning's events. The third development involves the special counsel's office. Until now, the superseding indictment filed in April has remained sealed. The reasoning for that secrecy was straightforward. Investigators wanted to maintain an element of surprise while arranging the process for Trump's formal surrender. But after what happened this morning, that calculation may have changed. If prosecutors believe Trump now understands the full scope of the additional charges, they may decide there is no longer a reason to keep the indictment sealed. In that case, it could be unsealed very soon, revealing exactly what new allegations investigators have added to the case. And that's where things could escalate quickly, because the broader implication of what happened today reaches beyond the immediate legal question of travel restrictions. Think about the precedent this situation is testing. For more than 2 centuries, the American legal system has operated on an assumption that when people are charged with crimes, even powerful people ultimately submit to the authority of the courts. What unfolded at Dulles Airport is forcing institutions to confront a different possibility. What happens if someone who once held the presidency decides that assumption no longer applies to them? And this morning, according to the court's emergency order, a federal judge concluded that possibility was serious enough to justify physically preventing a former president from boarding an international flight. That's not just a procedural moment, that's a constitutional one. And it raises a difficult question about how institutions respond when the person involved once occupied the highest office in the country. Several legal scholars have already said the same thing in different ways. The decision Judge Valdez made this morning likely came after reviewing evidence that convinced her the risk of flight was immediate and real, because issuing that kind of order, particularly against a former president, carries enormous political consequences for a judge. It is not a step taken lightly, which means if the reasoning eventually becomes public, The supporting evidence will probably be examined very carefully by legal experts, political observers, and historians alike. And that's why the next 72 hours matter so much. During that window, we may learn whether the court will release portions of the emergency order, whether Trump's attorneys attempt to challenge the restrictions, and whether prosecutors decide to reveal the full contents of the superseding indictment. Each of those decisions will add another piece to the picture. Right now, what we know is this: a former president arrived at a private aviation terminal with a flight scheduled to leave the country, and federal marshals, acting under a judicial order, stopped him before he could board. His passport was taken, the plane departed without him, and the court imposed conditions preventing any attempt to leave the continental United States. When historians eventually study this moment, they may not focus only on the legal arguments or the filings inside the courtroom. They may look at those 11 minutes at an airport terminal and ask whether that was the moment the justice system proved it could still enforce its own rules when confronted with someone who once held extraordinary power, or whether it revealed something more complicated about how institutions respond under that kind of pressure. And the truth is, we're still watching that answer unfold. So now we arrive at the part of the story that people inside legal circles are quietly debating, not just what happened this morning, but what it means from here. Because once the immediate shock of the airport interception settled, analysts started laying out the possible paths forward, and none of them are simple. Right now, there appear to be three realistic scenarios on the table. The first possibility, and some analysts think this is the most likely, is that Trump simply accepts the travel restrictions and remains inside the United States while the legal process moves forward. In that case, his attorneys would focus on preparing for trial rather than challenging the court's authority over his travel. Under that scenario, the case would move toward a trial sometime in the next several months. Trump would remain physically present in the country, complying with the restrictions imposed after this morning's incident. For prosecutors, that outcome solves the immediate concern about flight risk. The legal battle then becomes what it was already expected to be: a complex criminal trial involving obstruction charges and the additional counts described in the sealed indictment. But there's another possibility. Trump's legal team could challenge the emergency order itself. They might file an appeal arguing that the travel restrictions are excessive or unsupported by the evidence. If an appellate court agreed, Judge Valdez could be required to modify the order, potentially allowing limited international travel under supervision. In that situation, the entire question of whether Trump might attempt to leave the country could reappear under different circumstances. And that leads to the third scenario, the one that some prosecutors may already be considering. If investigators believe the events this morning demonstrated an undeniable flight risk, they could move to have Trump detained before trial. That would mean requesting that the court hold him in federal custody rather than allowing him to remain free under travel restrictions. Detention without bail is not common for white-collar defendants, but it can happen if a judge determines that no set of conditions can reliably ensure a defendant will appear in court. And the events at Dulles Airport will now be part of that evaluation. Each of these possibilities carries consequences that extend well beyond one defendant, because this case is touching a fundamental question about the limits of power in a constitutional system. For 249 years, the American system has relied on a basic principle that legal accountability eventually applies to everyone. Presidents leave office, courts continue functioning, and individuals accused of crimes appear before those courts to answer the charges. But that assumption only works if it's enforced. What investigators appear to have confronted this morning was the possibility that someone who once held the presidency believed leaving the country might be easier than confronting the legal process waiting ahead. And if that possibility had succeeded, if a former president had quietly boarded a private aircraft and established residence in a foreign country beyond the reach of American courts, the precedent would have been extraordinary. It would suggest that presidential power doesn't simply end when a term ends, that it can create a practical form of immunity once someone steps outside U.S. jurisdiction. That's part of why the response from the court this morning was so immediate. According to the emergency order, Judge Valdez concluded the evidence of flight risk was strong enough to justify stopping the departure in real time. That is a dramatic step. But the alternative, allowing someone to leave and dealing with the consequences afterward, might have created a far more complicated constitutional crisis. Now, there's another dimension to this that often gets lost in the political noise. The institutions involved here are not acting alone. Judges, prosecutors, investigators, and defense attorneys all operate inside a legal framework designed to balance authority and restraint. And when a moment like this happens, every one of those actors understands that their decisions will be scrutinized not just today, but years from now. Law students will study it, scholars will debate it, historians will probably write about it, because the question isn't simply whether one individual attempted to leave the country. The deeper question is whether institutions responded in a way that preserved the rule that legal obligations apply equally, even to people who once occupied the most powerful office in the country. That's the tension sitting underneath everything that happened this morning. And the next few days will begin revealing how that tension resolves. So before we wrap this up, I want to slow down for a moment and look at the broader picture. Because when events move this quickly, it's easy to focus only on the headlines and miss what the underlying test actually is. What happened this morning at Dulles International Airport wasn't simply a story about travel restrictions. It wasn't just a procedural step in an ongoing investigation. It was a moment where several parts of the American system, courts, law enforcement, prosecutors, had to decide whether they were willing to act when the stakes involved a former president. For most of the country's history, that situation has been largely theoretical. Former presidents traditionally stepped away from power, and legal conflicts rarely moved into territory that forced the courts to confront questions like this. But that assumption has been under pressure for some time now. And what we saw today was a federal judge reviewing evidence and concluding that the situation required immediate intervention. Not tomorrow, not after another hearing, immediately. The order was issued before sunrise. Federal marshals were already positioned at the terminal, and when Trump arrived to board the aircraft, they executed the order exactly as written. His passport was removed, the aircraft departed without him, and he was held under supervision long enough for the court's conditions to be formally communicated. Those 11 minutes may end up becoming one of the most studied moments of the entire case, because in those minutes, the question was very simple. Would the system enforce its authority or hesitate because of who the defendant used to be?